Estates and land. Defeasible fees. A fee simple estate of potentially infinite duration that can be terminated upon the occurrence of some specified event. Present fee simple estate vested in some person who may lose the fee interest upon the occurrence of some event. Or language that requires clear words of intent for the fee estate to be forfeited. So words of desire, hope, or aspiration are insufficient. 3 types of defeasible fees. The first is fee simple determinable, which is when the property automatically reverts back to the grantor upon a happening of a given event. So this accompanying future interest, possibility of reverter, retained by the grantor. 2, fee simple subject to conditions subsequent. So this is when the grantor retains power to terminate grantee's estate. So grantor must take action to terminate. It does not occur automatically. Accompanying future interest is the right of re-entry retained by grantor. And the third is a fee simple subject to an executory interest. This is when the property automatically transfers to a third party, which is someone other than the grantor, upon the happening of a given event. So the accompanying future interest it's shifting executory interest retained by a third party. And then we talk about the fee simple determinable. A fee simple estate that automatically terminates and reverts back to the grantor upon a happening of a given event or condition. So to A, so long as he practices law. If A stops practicing law, property automatically reverts back to grantor. The characteristics are an automatic forfeiture. So upon occurrence of a given event or condition, the grantor automatically forfeits the estate. This is potentially infinite, so the duration can be infinite so long as the event or condition does not occur. It's also transferable, so the fee estate is alienable, divisible, and descendable subject to the condition. Then there's the creation. It requires no clear duration language. Or it requires clear duration language, such as phrases such as for, so long as, while, during, until, etc. Words of desire, hope, or aspiration are insufficient. So accompanying future interest is a possibility of reverter. So a grantor retains a possibility of reverter, i.e., the property may revert back to the grantor, but only if the event or condition occurs. It's only inheritable, so the grantor's possibility of reverter must ascend to grantor's estates, intestate heir, attempted lifetime transfer, or devise is void. Fee simple subject to condition subsequent. A fee simple in which the grantor retains the power to terminate the grantee's estate upon the happening of a given event or condition. So an example is 2A, but if he wins the lottery, grantor reserves the right to re-enter and retake. Characteristics is that the forfeiture is not automatic. If the event or condition occurs, grantee still retains the title until the grantor exercises his re-entry right. This is what distinguishes fee simple subject to condition subsequent from a fee simple determinable. So it's potentially infinite. The duration can be infinite so long as the event or condition does not occur. It is transferable, it's alienable, divisible, and descendable subject to the occurrence of a given event or condition. The creation, there must be clear durational language, and it must carve out a right of re-entry for the grantor. So it must be explicit that the grantor has the right to retake upon occurrence of the event or condition. Words of desire, hope, or aspiration are insufficient. accompanying future interest or the right of reentry. So the grantor retains the right of reentry. Only inheritable. Grantor's right of entry must ascend to grantor's intestate heirs. Attempted lifetime transfer or devise is void. Fee simple subject to an executory interest. So a fee simple that automatically transferred to a third party upon happening of a given event or condition. So 2A, but if he wins the lottery, 2A, but if A is ever arrested, then to B. So characteristics is an automatic forfeiture. Upon occurrence of the event or condition, estate automatically transfers to a third person. This is similar to a fee simple determinable, but ownership automatically transfers to a third person, not the grantor. This is potentially infinite. The duration can be infinite so long as the event or condition does not occur. It is transferable, alienable, divisible, and descendable subject to the occurrence of the condition or condition. Absolute restraints on alienation are void. Creation is clear durational language is required. So 2A, but if A gets married, then to B. Words of desire, hope, and aspiration are insufficient. Accompanying future interest is a shifting executory interest. So the third party holds the shifting executory interest. It is transferable. A third party interest is alienable, divisible, and descendable. And then we have life estate, an interest that lasts only for the life of the interest holder. So for an example, O grants 2A for life. A has a life estate and the life tenant until she dies. So defeasibility, it can be defeasible like fee estates. For example, it's determinable, subject to a condition or executory interest, or indefeasible. So life tenant has all ownership rights, but must maintain property and make reasonable repairs. Life tenants cannot commit waste. Accompanying future interests. Reversion or remainder, not provide the deposition of property to a third party. So O, 2A for life, A is the life tenant, O has the reversion, or the property reverts back to O when A dies. Remainder is the future interest following a life estate that identifies a third person. So the third person has a remainder. O to A for life, then B. A is a life tenant, B has a remainder. When A dies, property goes to B. Life estate is measured by the life of someone other than the life tenant. So O grants 2A for the life of B. A is the life tenant holding the property until B dies, at which point the property reverts back to O. Transfer of life estate. This creates an estate, PAV, held by transferee. So the life tenant transfers the life estate to B, and B holds a life estate that reverts to the grantor, O, when the life tenant dies. Then there's the doctrine of waste. A life tenant cannot commit acts that constitute an unreasonable use of land and or injure the interest of a future interest holder. Doing so would constitute waste, of which there are 3 types. The first is affirmative waste, which is voluntary. A life tenant cannot consume or exploit natural resources on the land except A, where necessary for repairs or maintenance of land, B, when a grantee expressly gives the right to exploit, or C, if the land was used for exploitation of resources prior to the grant. So this is like the open minds doctrine. If exploitation occurred before the life estate, the life tenant may only extract from already open mines. Then there's permissive waste, harm to property due to life tenant's neglect. Life tenant has a duty to repair and maintain property up to the extent of income or profits derived from the land or its rental value. This includes paying for taxes, interest, or encumbrances. Future interest holders who assume life tenant's obligations are entitled to reimbursement. And then there's ameliorative waste, which is when the life tenant acts that economically benefits the land. It's prohibited under common law, but now usually permitted in most modern jurisdictions. A remainder is a future interest in a third party other than the grantor that arises immediately upon the termination of a preceding life estate. So 2A for life, then B. A has a life estate and B has a remainder. The characteristics are creation, which is expressly created in the same conveyance in which the preceding estate created. It's transferable, so it's alienable, divisible, descendable, and it cannot cut off or divest an interest held by a prior transferee. Categories of remainder are 1, vested remainder, which has 3 types: indefeasibly vested remainder, vested remainder subject to total divestment, vested remainder subject to open, and then there's contingent remainders, which arise if there is a condition precedent to future interest becoming possessory, the future interest vests in an unascertained taker, or both. And then a vested remainder is a remainder that automatically becomes possessory upon the natural expiration of the preceding estate. So the limitations are that the vested remainder cannot be subject to any condition precedent or vest in an unknown or unascertained person. There are 3 types of vested remainders. 1, indefeasibly vested remainder. This becomes possessory immediately upon termination of the prior estate. So 2A for life, then to B. Vested remainder subject to total divestment. This is subject to some conditions subsequent, such as remainderment, and it could be divested after taking possession. So for example, 2A for life, remainder to B, but if B weeds to C. So the vested remainder subject to open is like a class gift. So the remainder vested in a described class of takers, at least one of whom is capable of taking possession. So like just by virtue of being alive. So if 2A for life, remainder to children of B and their heirs. So B has 1 child who is a vested remainder subject to open because B may have more children. So open versus closed class, a class stays open to allow for future members and closes when no members can be created. So the life tenant dies. The rule of convenience is that the class closes whenever any member can call for distribution of her share. So after-born class members get nothing. Then there's the contingent remainder. This is a remainder will be contingent if it is either subject to a condition precedent or created in favor of an unascertained or unborn person. So this is subject to condition precedent. Remainder is taking is contingent on the prior occurrence of some event or condition. Once the event or condition occurs, the interest automatically becomes an indefeasibly vested remainder. So 2A for life, then to B and his heirs when B gets married. So if B is unmarried at the time of the conveyance, A has a life estate, B has a contingent remainder. Because marriage is a condition precedent, a grantor has a revision in case B is not married when A dies. If B gets married, he has an indefeasibly vested remainder, subject to unborn and unascertained persons. So a remainder created in favor of unborn or unascertained persons, i.e. remainder is contingent on grantee being born or ascertained. So for example, to A for life, then to B's heirs. If B, remainder is contingent because heirs of B cannot be ascertained until B dies. Rule of destructibility. The law has created rules to prevent some consequences that may result from strict application of the estate system's requirements. So the rule of destructibility at common law, a contingent remainder is destroyed if it remains contingent. The condition is not satisfied when the preceding estate ends. So for example, O grants to A for life, then B once he goes to law school. A dies and B has not gone to law school. At common law, B gets nothing upon A's death. Modern rule, it gives a reversion to the grantor or grantee's estate until grantee satisfies the condition. Merger, or Shelley's rule, arises when a conveyance attempts to give a life estate to grantee with remainder to grantee's intestate heirs. So at common law, the two estates merge. For example, O grants to A for life, then to A's heirs, and A is alive. At common law, the remainder merges, and A has a fee simple absolute. The modern rule is A has a life estate, and his heirs have contingent remainders. So O has a reversion because A could die without heirs. Then there's the doctrine of worthier title. This arises when the grantor creates a life estate in another, but creates a future interest in grantor's heirs. For example, O grants to A for life, then to O's heirs. Under the doctrine, the contingent remainder in O's heirs is void. A instead has a life estate and O has a reversion. Then there's executory interest, a future interest in a third party that takes effect by cutting short some interests. There are two types, shifting and springing. This includes any future interest that is not a remainder. So you want to look for it indicated by phrases like but if, then to, for, so, long as. These executory interest holders lack standing to sue for waste. The transferability, it's divisible, descendable, and usually transferable. So with the shifting executory interest, it always follows a defeasible fee or a vested remainder subject to total divestment. So it cuts short someone other than the grantor. For example, to A, so long as the property is used for storage. But if used for other purpose, to B. A has a fee simple subject to executory interest, and B has a shifting executory interest. If A stops using the property for storage, A's interest is cut short, not grantor's. Then there's the springing executory interest, which cuts short a present interest held by the grantor or the grantor's estate. So for example, to A, if and when he gets married, A has an executory interest and the grantor has a fee simple subject to an executory interest. If A gets married, possession springs from the grantor to A. Rule against perpetuities. No property interest is valid unless it must vest, if at all, no later than 21 years after the death of a life in being at the time the interest was created. A future interest is void if there is any possibility, no matter how remote, that it will vest more than 21 years after the death of the measuring life. The measuring life is a life in being when the interest was created, whose actions during life, at death, or within 21 years after death determine whether a future interest satisfies the RAP. Analyzing a conveyance subject to the RAP. 1. Determine the interest being granted. 2. Apply RAP to future interest that is contingent remainder, an open class gift, or an executory interest. 3. If conveyance violates the RAP, strike only the violating future interest. What remains is the new conveyance. Note, many states have reformed the common law RAP, providing that an alternative vesting period greater than 21 years, unless instructed otherwise, apply the common law RAP. And then there are special considerations regarding the RAP. There's rights of first refusal in RAP. This is a contingent interest and property. So options and rights of first refusal, they violate RAP if they could possibly be exercised outside the time period allowed by RAP. So class gifts in RAP. For class gifts to satisfy RAP, a class must be closed with all condition precedents satisfied for every member. The rule of conveyance for class gifts may save a class conveyance that would otherwise violate the RAP. Examples of RAP violations are 1. Age contingency beyond 21. So a conveyance to an open class is contingent on members reaching an age over 21. So this is void under RAP because it cannot vest within 21 years of the life in being at the time of the creation. And 2 is fertile octogenarian. This is a presumption that any woman is capable of giving birth regardless of her age condition. So a grantor conveys to A for life, then to age children who reach the age of 30. A is 80, her son is 40. This violates the RAP as A's son could die and she could have a daughter at 81, then die when she is 82. The remaining daughter interest will not vest for another 28 years. Then there's the charity to charity exception. RAP does not apply to conveyances from one charity to another.